Good morning, everyone. I'm Jenny Panteli, investment consultant at Feod Group, Cyprus. A constant theme in our first meetings with investors is property ownership security in Cyprus, especially for non-EU buyers. To make these answers available to everyone considering a purchase, whether personally or via a company, I've invited our firm's lawyer director, Christofido. Thanks for joining me.
Hi. Nice to meet you.
Let's start with a quick overview. From a legal standpoint, what are the main pillars to protect a foreign investor's property rights in Cyprus today?
Okay, Cyprus offers a very strong legal protection for foreign investors based on several key pillars. Firstly, Cyprus constitution guarantees the right to property and compensation in case of expropriation. Secondly, our land registry recognizes and secures ownership through the issuance of title deeds under the local property laws which are updated on a regular basis. Thirdly, we are an EU country, so EU law reinforces these protections, especially for EU nationals, through principles like free movement of capital and non-discrimination. And fourthly, Cyprus has signed multiple bilateral investment treaties offering safeguards to investors like fair treatment and access to international arbitration. And finally, the independent judiciary and enforceability of contracts make Cyprus a legally secure jurisdiction for real estate investment.
Let's say a non-EU citizen wants to buy 6 residential units, which exceeds the 2-unit individual cap. So first, could you walk through the step-by-step process when a non-EU investor forms or uses a Cyprus company to acquire more than 2 residential units?
Okay, the procedure of setting up a company in Cyprus is pretty simple and straightforward. It does not matter if the investor is EU or non-EU, the rules for incorporating a Cyprus company is the same for everyone. The step-by-step procedure, I think it's not time now to discuss it in this interview because it will take some time, but there is only one thing I would like to highlight. The investor should make sure that the articles of association of his company cover the ability of the company to purchase a property or do any other investment in Cyprus. Therefore, a lawyer should be engaged to undertake the registration procedure of the company and make sure that the articles of association will not create any problems in the future.
Very good. Which authorities must approve a transaction? The Council of Ministers, the Central Bank, or others? And what timeframes should the buyer plan for?
Okay, the Council of Ministers, just to clear things out, is involved only when an EU national is purchasing a property directly. If the investment will take place through a Cyprus company, then there is no need for the approval of the Council of Ministers, even if the owner of the Cyprus company is a third country national. Now, the actual transaction does not need to be approved by any authorities. However, there are steps that should be made prior to the acquisition of the property. For example, it is important to get approval from the bank, any bank that maybe the developer is cooperating with or the investor is interested to open bank accounts, so that the funds of the investor are pre-approved by the bank before engaging and himself in purchasing a property.
All right. Once those 6 apartments are rented out, what taxes apply?
Okay, first we need to consider what taxes apply at the acquisition of those 6 apartments, and then we can discuss the taxes applying when we are renting them out. So firstly, when a property is being sold, there is either VAT or transfer fees. If the purchase is from a developer, we call it first sale, then only VAT applies. And if it's a resale, then there are transfer fees applied. Never, in no cases, there is VAT and transfer fees at the same time. The purchase of a property is completed when the title deed is registered on the name of the buyer, and on the day of title registration, the land registry office estimates the market value of the property that will be purchased and charge the buyer transfer fees. Those transfer fees range from 3 to 8% on the property price, depending on the property market value. It is worth noting, though, that there is currently a 50% discount on the transfer fees to be paid. As mentioned before, it's very important for the potential investor to know that transfer fees are not chargeable at all if VAT applies. And there is also another levy where the seller is paying it, called which is 0.4% on the value the land registry decides that is the market value of the property. Now, so we acquired the property, we paid either transfer fees or VAT, and now we are ready to rent it out. So when a Cyprus company owns rental property, the tax implications are completely different from owning the rental property as an individual. The rental income earned by a Cyprus company is subject to corporation tax, which is currently a flat rate of 12.5% after deducting any expenses related to the property. So any rental income from the Cyprus company, we have 12.5% tax. There is another contribution called special defense contribution, which is similar to individuals. Companies pay special defense contribution at the rate of 3% to the 75% of the gross rental income. This special defense contribution does not apply though in cases of Airbnb. However, certain conditions must be met in order to disregard the property and not pay special defense contribution. Another contribution is the general healthcare system. If you are an individual and you own a property that is being rented out, you pay general healthcare system contribution. If you are a company, the owner is a company, then there is no such contribution. Companies do not pay general healthcare system contributions. And lastly, VAT. VAT on short-term rental, short-term meaning a few days to a few weeks for tourist accommodation mainly, is subject to a reduced VAT rate of 9% instead of 19, provided of course that the VAT authorities pre-approve the discounted VAT rate of 9%. And VAT is not applicable on leasing of properties used for residential purposes. For example, the company being the owner rents the 6 apartments to 6 different individuals, and those individuals are using it as their residential apartment, then there is no VAT, the VAT is not applicable. And lastly, the owner should also consider some other small levies, for example, municipality taxes, garbage collection fees, water, electricity fees, communal fees in case of a complex. And this usually, who pays them is a matter of agreement between the landlord and the tenant who will pay what.
Now the next question. How does holding property via a company affect the investor's security compared with owning in their own name?
Okay. Holding a property through a company in Cyprus offers asset protection, privacy, and flexibility. Especially, it's useful for estate planning or joint investments. For example, it's much easier for a company to own 6 flats and the owners of the company to be 7 individuals, 7 investors, instead of those 7 investors owning a different apartment or share of the apartments, all 7 of them together. It is generally better suited for larger income generating investments to use a company rather than if the apartments are used for a personal use, then there is no point to have a Cyprus company involved. All in all, we would advise that purchasing 6 flats through a company is better since the purpose of the purchase is for investment.
Very nice. Let's go to another scenario. Let's say non-EU citizen acquires a Cyprus company that already owns land plots. So many investors ask whether to buy land directly or buy the shares of a company that owns it. Legally, how do those two routes differ?
So, if the land will be used for a personal use, for example, be the residential property for the use of for own use of the investor, then the investor should purchase the property directly. If, on the other hand, the land will be used for investment and to generate income for the investor, then it is best to purchase the shares of the company that owns the land.
Before signing, what due diligence checks are absolutely critical?
Firstly, we should not regard any checks to be less critical. All checks are absolutely critical, even to the small detail, because we are handling the investor's money and we need to make sure that he will not do an investment that it will fire back to him in a negatively. So everything is absolutely critical, and the first thing that we need to do is check at the land registry office, to make a search basically at the land registry office to check whether the land is free from any charges or other encumbrances. Secondly, we need to check the company that owns the land from both a corporate and a financial point of view. For example, we need to check whether the shares of the company are pledged. We need to check who are the owners of the company, whether the company has any loans to third party, or even if the company has any other liabilities, for example, past due taxes that the investor will come, buy the company, and then all of a sudden the company is in debt. Another thing that we need to check is whether the land is suitable to be developed the way the investor wants it to be developed. For example, maybe he wants to develop a hotel, but the land and the geographical position of the land will not allow him to construct and invest and develop a hotel. So yes, all in all, it is very crucial. All aspects are checked, properly checked by professionals in Cyprus. That it is important that these professionals have the know-how and the background and the experience to be able to see and to identify quickly before the investor makes any further steps, and especially before the investor pays money for the investment, to make sure that everything is clean and the investor can proceed with his acquisition.
Good. Could you outline the mechanics of a share purchase agreement in Cyprus, like stamping, share transfer forms, land registry notifications, and how do stamp duty, capital gains tax, or transfer fees compare with a direct land transfer?
Okay. Firstly, since the investor in this case, in this scenario, is a company, then the land registry office is not involved at all, meaning that the land registry office has the owner of the property of the land is a company. We will transfer the shares of the company, so the owner will remain the same. It will be the same company. So we have nothing to do with the land registry office when it comes to selling the shares of a company for the investment. The shareholder, though, that will transfer the shares to the investor will need to go to the tax office and pay capital gains tax, because the company he's selling has a property. So capital gains tax needs to be paid by the seller, but this tax does not concern the buyer. The buyer needs to make sure, of course, that these are paid and continue with the acquisition. Now, there are the transfer fees associated with property transfers also are not applicable, because there is no direct property transfer. We are transferring the shares of the property. And lastly, the only thing that is applicable, and we need to make sure that it's drafted properly, is the share purchase agreement, whereby the shares of the company will be transferred to the investor. The share purchase agreement should contain all clauses to make sure that it safeguards our investor, and clauses, for example, at which point the shares are transferred, before or after the payment, or the whole or part of the payment. So there are a lot of things to consider in the SPA. Therefore, a legal professional should be engaged to draft it according to the investor's wishes.
Now, after the share changes hands, what must the new owner do to ensure the land plots remain fully secured under the company's name? For example, updates at the Register of Companies, pledges, or caveats.
As long as the due diligence process is performed prior to the transaction, prior to the acquisition of the shares, that is, then the land is owned by the company, and there are no further steps to be taken to make sure that the company is the rightful owner of the land. The only procedure that we must follow is to update the Register of Companies regarding the new shareholder owner of the company, and I assume that as soon as the new owner is the owner of the shares of the company, then he will also change the director of the company, the secretary, maybe the registered office of the company. And these are documents that, firstly, it will be covered in the share purchase agreement we discussed earlier. And we will update the register of companies regarding these changes and obtain the new certificates. Other than that, there is nothing else to be done to secure the investor being the shareholder of the company.
Thank you, Christo, for clarifying those scenarios. Before we close, what 2 or 3 tips would you give any non-EU investor to make the Cyprus property journey smoother and safer?
I will give you one big tip. I would strongly advise the investor to engage a professional, a lawyer in Cyprus, to guide him through the whole process. Although it sounds a simple process, it's simple if you have the right person next to you to make sure and safeguard your best interests. Make sure that there will be no surprises on the way, predict possible problems and overcome these problems before any investment takes place. So yes, my one tip is to engage a professional through the whole procedure. And of course, we are here to assist. We are a team of professionals, from lawyers to consultants to financial advisors, tax advisors, VAT experts, property experts, and we are all committed to work together and help our clients, assist them in the best case possible.
Thank you very much. And finally, we hope this conversation was helpful and insightful for you. If you'd like to learn more about or get tailored advice on your specific situation, feel free to visit us at our office in Larnaca, or simply Google Feod Group and reach us through our website investment-cyprus.com. We'll be happy to assist you.